Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. My name is Dan Balkaran, as you see on the screen, and I am an employment lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee-side employment law firm. I'm going to be answering all your questions about all things employment law for the next 30 minutes or so. Please, I want to try to get to all the questions. So please send your questions in as soon as you have them, and I'll try to get through to all of them. Apologies, there is some construction going on right near my office, so if you hear it in the background, that's what it is. Unfortunate timing with the construction, but there's not much I can do about it. So just bear with the noise if you hear it. Okay, good. Let's get going here. So, question from no name identified. I have proof I was discriminated against in getting hired based on skin color. Can I claim lost wages for the time I got proof to the time of hearing? What steps should I take to find employment? There's a whole bunch missing from your question here because you got discriminated against in the course of hiring, but did you get the job? In which case, I don't know how it would be discrimination or discriminatory. You mean you didn't get hired because of your skin color? And then what are the remedies for that? So, each human rights jurisdiction probably does it a little bit differently, but I'll just speak to British Columbia where I practice. Although the regimes are substantially similar, and again, I apologize for the noise. The regimes are substantially similar across the provinces. There are variations, so certainly, if you're not in British Columbia, talk to a local employment lawyer to get specifics on the human rights regime. But generally speaking, lost wages, like severance, and quite often it can be from the date of termination to the date of hearing in the event of a termination, employment and termination. But on top of that, you have what is in BC called injury to dignity. So if there's, I'll back up here for a second. If there has been discrimination, and in BC at least, if the Human Rights Tribunal determines there's discrimination, you can get lost wages from the date of termination to the date of hearing, subject to when the tribunal would impute that you should have found a new job, because they're not going to have, in BC, there's about a 4 or 5 year backlog for a hearing right now, and certainly the Human Rights Tribunal is generally not going to impose that kind of penalty on an employer where they'd have to pay 4 or 5 years of lost wages. So they'll determine if the employee can reasonably find a job and what that time frame would be. However, there's a second component to the remedy, or to remedies available when there's been a discrimination. So if it's discrimination in termination, lost wages are available, which are like severance. But in addition, the act of discrimination itself is compensable in and of itself for the injury to the dignity you have suffered by the discrimination. And those damages tend to be smaller, although they have been getting larger, and they're informed by 3 factors: the vulnerability of the individual coming in to the discrimination, the egregiousness of the discrimination, and the impact on the individual coming out of the discrimination. And so I think the last 2 really move the needle. If they're heinous, it was heinous discrimination on the part of the employer or potential employer, and it really had an impact upon the individual, then certainly that damages figure can be a lot higher. Even for serious matters, though, I mean, in BC, I think historically the high water cap was about. Well, I mean, they tend to be limited, but they have been getting bigger. I'll just say that, depending upon the seriousness of the discrimination and the impact on the individual. In your case, if you weren't hired, then you don't have a lost wages remedy available, from what I can see. But you would have an injury to dignity remedy. What that would be, again, would be determined by your vulnerability coming in, the egregiousness of the conduct, and the impact coming out. And I will say that there are very few employers in Canada that will ever come out and say, we didn't hire you because of your skin color. I've never seen that. Now, you don't need to prove your case at the Human Rights Tribunal to a high standard like beyond a reasonable doubt. You don't even need to get to more likely than not. It just has to be a good arguable case, and then the employer can defend its position. But generally, in my experience, that those cases when you're claiming discrimination on the basis of race or ethnicity, you're going to need some evidence because those things are very difficult to prove. Hope that answered your question. Heather asks, I was let go for reporting an inappropriate relationship in the workplace. Is this a wrongful dismissal? Not in and of itself. So what a wrongful dismissal is, at its core, is that the employer has terminated you and not provided you with sufficient notice of the termination or sufficient pay in lieu of notice of the termination. And by sufficient, I mean your entitlement at law, whatever that would be. And there's lots of play in those joints. It varies substantially based on what your contract says, and then your age, length of service, position, how long you're going to be unemployed for. So that's what makes it a wrongful dismissal. The question you're asking is, if the employer paid you zero, if it terminated you for just cause, is you reporting on an inappropriate relationship in the workplace just cause? I would say it's not. But if they didn't terminate you for just cause and terminated your employment without cause, then and again, sorry, just to back up here a second, the remedies at law that exist for the breach of contract that is potentially inherent in a termination, and I say potentially because you might have been paid the correct amount of pay in lieu of notice, it's always money, right? So the solace is money. It's not in very rare, specific and rare circumstances, it can be reinstatement to your job, but generally speaking, it's money. Okay, so that's what we're talking about here. And so if your employer terminated you for just cause and you got no money or no notice of your termination, then would what you did be sufficient to uphold the just cause $0 zero severance termination at law? The answer is no, in my opinion. I mean, I'd have to know more, but just reading your one sentence question, I'd say no. But if they paid you pay in lieu of notice or provided you notice of your termination, the question is really, did you get enough at law? And if the answer is yes, then there's no wrongful dismissal. Now, if you have a claim for wrongful dismissal because they didn't pay you enough, is termination for what you did some sort of aggravating factor, or that you can claim some sort of additional compensation, such as breach of duty of good faith for punitive damages? Probably not. Your employer can terminate you for any reason, provided it complies with the law with respect to providing you sufficient notice or pay in lieu of notice. I hope that answers your question, Heather. Question from R. I'm not going to identify him. When my wife was working at a small hospital and we were renewing her visa and applying for citizenship, she had a letter from immigration saying she could continue to work. Human Resources told her they would terminate her when her visa expired and her last week of pay until she came back. I don't know what this. There's no question here. I mean, I can sort of glean what it is, but I don't practice immigration law, so I don't know anything about maintaining visas and citizenship and the employment component of that. So you may want to speak to an immigration lawyer about that. Mitch asks, my friend was fired after putting in notice for a medical leave. He was coming up to a contract renewal period. about 3 weeks out, does he have any severance entitlements? Well, so it's an interesting question, the way you phrased it. If your friend was on a fixed term contract, so sometimes it's rare, but employers can engage someone as an employee for, say, 1 year. So we're going to employ you for 1 year from August 1 to 2025 to August 1, 2026. And your entitlement for notice or pay in lieu of notice if they terminate you today is the remainder of the year, regardless of when they terminate you in the year. So if you're terminated on August 2nd, you got a year's pay coming to you. But if they terminate you on July 30th, the following year, you have almost nothing coming to you, and that's sufficiently legal. Okay. However, your employer can terminate you and not be on the hook for the entire year if it has a termination clause in your contract that provides you with notice or pay in lieu of notice that complies with the employment standards legislation, the notice sections of the employment standards legislation in your particular provincial jurisdiction. So with respect to your friend, if he was on a fixed term contract, then yes, he might be only entitled to the 3 weeks of notice, and that's it. However, if you mean something else by contract renewal period, and there is no contract renewal period, or it's not a fixed term contract, then he certainly might have severance coming to him, and he should speak to an employment lawyer. Also, if he was terminated by, when he said, I'm going on medical leave, then certainly he's got a human rights complaint for at least injury to dignity, as I spoke about earlier. Now, his damages for that might be small, and if he's in BC, he might wait a long time for that if he can't reach some sort of settlement with the employer. And again, I apologize for the noise in the background if you can hear that. As I said earlier, there's some intermittent construction going on right outside of my office. If he's only got a claim in discrimination with respect to disability for saying I'm going on medical leave and then being terminated, whether or not he's got a lost wages claim that has any sort of value to it depends on if he did have a fixed term contract. And so because it may be there's only 3 weeks left in that fixed term contract. So Mitch, I think what you've asked is a complicated question. There's not enough information in what you've provided for me to really sort it out. So I think you should talk to an employment lawyer, or your friend should, as soon as he can. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, at 1-855-821-5900. Okay. Shan asks, have you ever had a client sue WCB for releasing your entire file to the employer without signing a third-party media? FIPA and PHIA, those are pieces of legislation or regulation around privacy, I imagine. I know what FIPA is, but PHIA might be as well. Breach in their own policy, especially as the employer has no human resources. No, I have no experience in that. I know very little about privacy law. It doesn't intersect with my practice very much, and that tends to be because there aren't really strong defined remedies, i.e. monetary penalties, as I understand it, within the various overlapping privacy legislative regimes. And so I just never encounter it. So there are certainly lawyers that have expertise in privacy legislation, and you may wish to contact one of them, but I'm certainly not one of them. And I don't know anyone at generally speaking, it's not something that we practice. Also, by and large, individual employment lawyers don't do a lot of WCB work, although some do. So you may have to get your question answered, you may have to hunt around for a lawyer who practices in those niche areas. Sorry, I could not be of more help, Shan. Okay, question from Owl. I started a night shift job in November with a contract stating I'd have to repay 1 month's salary for training if I left before the 1 year mark. However, the training was minimal. I mostly learned on my own using a manual while shadowing someone who just did their normal job. The night shifts have negatively impacted my mental health, and I'd like to leave or switch shifts. Given the lack of structured training and my health concerns, is it legal for the employer to enforce repayment? I'm in BC and would appreciate any advice on how you handle this. Well, you have to determine what it is that you want. If the night shifts are hurting your health, then you could get a medical note from your doctor saying you, for health reasons, must work day or evening shifts, not night shifts. Where that could be a challenge, though, for you, and you probably want to get legal advice, specific tailored legal advice on this before you do that, is if you were hired specifically for the graveyard shift, okay, I assume that's what you mean by night shift. If you were hired specifically for the graveyard shift, then being able to work graveyards is a core function of your job. And if you can't work that shift medically, it's, in perpetuity, if that's what your medical note says, it's entirely possible that your contract of employment with your employer has been frustrated due to your medical situation. And by frustrated, I mean it's a legal contractual term. It means that the obligations of both parties, so your obligation to work and their obligation to pay you and their obligation to provide you with severance, are all just extinguished. Okay, so if you can't do the core functions of your job, number one, number two, on a permanent basis, and your doctor says something like you can't work night shifts again. If you were specifically hired for the night shift only, yeah, I think your employment could be frustrated. So you have to be very careful with that, because you might find you don't have a job and you don't have a right to severance, and you're just done there. Again, sorry about the noise. I don't know how loud that is outside. It just popped up right before I began the broadcast, so my apologies. So you have to worry about that if that's what you decide to do. You may also be able to come up with an amicable solution with your employer. Like you could say, listen, I've been doing this for a year. I've been having some challenges. Can we move me to the day shift? I can't work evenings. Like, they may do it, but that's another one. With respect to your training question, so whenever you have a repayment clause with respect to education, it's always because the employer has incurred a cost. So we're going to pay for your certification somewhere, or your courses, your post-secondary courses, or your vocational training courses, or whatever it is. But we want to recoup our investment in the form of your labor that we have contributed to the skill level of across a certain amount of time. And if you lose your job for whatever reason, we either terminate you or you resign. In that period of time, we want our costs back for that. That's what they've effectively said to you, but they've claimed that for in-house training, which was just a sunk cost. It wasn't anything. So, I mean, they would have to prove, I think, that listen, I've never seen that before. I've never seen any cases on that before. And so I don't know anything specifically about what you're asking. However, I would say generally, I can't, if they would have to show some sort of loss. And, you had to shadow someone who was doing their job anyway, isn't a loss. So I think they would have some challenges enforcing that. They'd have to prove what their actual monetary loss was. If it doesn't set out what it's different than when you're going to a certificate program or school or something, where we know how much that costs. Here's a line item, must repay, right? But if it's just internal cost, I can't speak with any sort of certainty on that. I would just be surprised if if they were to prevail, the employer were to prevail on that repayment clause based on what you're telling me. But that's strange enough, and your situation is nuanced enough with respect to you need to know before you take any action if you were specifically hired into that graveyard shift, because you could, if you medically can't do it, that could be the end of your job. I think you should talk to an employment lawyer. If you want to talk to us, you can do that. employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. And so the question from Al, I just want to say generally, and this suffuses everything that I say. I'm, at least in this medium, I'm looking at 1-2 sentence questions, totally devoid of and deprived of context, and documents and facts and everything that a lawyer needs to give a proper opinion and a proper advice on a matter. And so while I'm generally providing my impression of each person's question, or their situation, or my take on their situation, it is not a substitute for proper, tailored legal advice. And before taking any action, generally, you should get legal advice. Leanna asks, I've been dealing with a coworker who's been causing me a lot of problems. They make changes to my work and do subtle things to cause me a lot of problems. What's the best way to deal with this? Yeah, so absent something egregious that so the short answer is I don't know, but this is not an employment law situation. Humans working with other humans in a workplace, some of them are inevitably going to get into disagreements, conflicts, etc. And the courts aren't going to, and have not, commercially criminalized such, for lack of a better term, such disagreements. So, if you can't get along with your coworker or your boss, but they haven't done anything that rises to the point of legal intervention or legal remedy, then it's just, humans trying to navigate a workplace with other humans. So in your case, do you talk to your boss about what you've been experiencing? Well, if what you've been experiencing is very trivial, your boss might think that actually you're the one who's been overly sensitive about the situation. Or I know when I used to run call centers for major technology corporations, lots of times, my staff would butt heads, and then they would come to me and demand that I make a decision about their butting of heads or keep the peace. And I can tell you, I wasn't impressed that they couldn't solve their own problem. And I directed them quite often to solve their own problems. And they often did, and they managed to figure it on their own, and unless I had to step in. But no boss likes dealing with the unnecessary dirty laundry of employees. And I'm not saying that yours is unnecessary. I'm just saying if you do report it upstream, you have to consider what that looks like for you, what your boss thinks of you, coming to them as opposed to dealing with the matter directly. But sometimes it's impossible to deal with an individual personality directly. Lots of people are impossible to deal with. It could be this person is malicious. It could be this person is trying to get you fired so they can take your position. Who knows? I don't know. You're on the ground there, and the environment, culture, and politics of your workplace. And so you have to make the best decision for you based on the information you have. But if it's subtle, challenges have been subtle and don't rise to the level of something egregious enough that employment law remedies are triggered, there isn't much assistance that an employment lawyer can provide you. Sorry, Leanna. Okay. Well, we're raced along quickly today. We've got one more question left. I'm going to see if there are any more in the pipeline. Question from Wallaby. I was suddenly suspended. Well, hold on. Before we get into Wallaby, so Leanna said, "Okay, thanks anyway. It's made for a very uncomfortable environment for me." Yes, Leanna, and I'm not unsympathetic to that, and I get it. I don't know what the best way is for you to handle it. I certainly don't have all of the information. But if it becomes a situation where there's bullying and harassment, or anything that triggers a human rights protected ground like sexual harassment or something of that nature, then you can get an employment lawyer involved. But only you know the tolerances of your workplace, and so you'll have to decide how to thread them. And is this something where you could sit this person down and just say, hey, we've been butting heads. Why don't we go for coffee and hang out? I'd like us to be friends, or something. Who knows? I don't know, but you will know what the best way to navigate it. But I appreciate that some people you just can't navigate, and unfortunately, I don't have a legal remedy for you in that situation. Okay. Wallaby says, I was suddenly suspended and later told I had quit because I didn't send an end of day report for a short shift, even though I had explained the delay and I followed up multiple times. My manager and human resources, who is also the wife of the manager, ignored my messages, withheld my paycheck, and claimed it was frozen due to company loss. I'm sorry, I'm not laughing at your predicament, but the actions of the employer are, you don't see that every day. That occurred after my paycheck was due. I'm a new immigrant and student. I'm unsure how to handle this. What are my rights? What should I do next? Okay, so Wallaby. So there are questions that need to be answered here, and unfortunately, it's hard to really get to all of it because of this is just sort of a short question and answer medium. But I'll say the first question. So if your employer said, well, you quit because you didn't fill out some paperwork and then withheld your money, you absolutely have a claim for some sort of wrongful dismissal. You're owed your last wages and you're owed severance for your termination if you're an employee. Okay. But second question you have to ask is, were you there long enough and were you making sufficient money that your claim is worth enough that you can get a lawyer involved? So, for example, if you were there for less than a year, as you said, you're new immigrant and a student, so it might be that you haven't been working there very long, and I don't know what you were making in terms of money, but if it was on the lower amount and you weren't there very long, less than a year kind of thing, it's probably not something that you can get a lawyer involved for, because the amount of money that's available, if and when you're successful in your claim, would be it's just not sufficient for you to incur the legal fees involved. And so it may be that the best thing for you is to pursue a remedy through the Employment Standards Branch, or whatever it's called in your provincial jurisdiction. If you are provincially regulated, which 90%, 95% of us are, you're entitled to your wages up to the last day of your work. So you need that 100% you're entitled to, and pay in lieu of notice, which if you've only been there for a year or less would be a week. A little bit more might be 2 weeks. So you're certainly entitled to those things. Could you claim other creative remedies to the Employment Standards Act in your region because of the problematic behavior and the willful violation of core tenets of the Employment Standards Act? You might be able to. You might be able to claim there's some creative arguments I've seen claiming a make-whole remedy through the BC Employment Standards Act. That would be from the date of termination to the date of hearing, which means you might be able to get 12, 13 months pay out of them, depending on the nature of your situation. So you may wish to talk to an employment lawyer, but it may be that your matter is something that is best handled by you through the employment standards regime. But I know in BC, I don't know about other jurisdictions, you got 6 months from the date of in this case, the termination of your employment to file your Employment Standards Branch complaint. So don't miss that deadline. But you may want to handle this matter yourself through employment standards. However, if you want to talk to an employment lawyer, and for everyone who wants to talk to an employment lawyer and you want to talk to us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, 1-855-821-5900. Okay, that was it. We got all your questions answered. Thanks for sending them. They were great questions. I hope everyone has a wonderful and safe weekend. I believe it's a long weekend. Wonderful and safe long weekend. I think that's right. And then join us next week for we have, there it is, with Alex Lucifero on August 7th, employment law Q&A, 12:30 p.m. Eastern time. Join us for that. Alex practices out of our Ottawa office, so that'll be great. And I think there's one more coming up. I think there's a disability law Q&A coming up as well. There it is, August 5th, 10 a.m. Pacific time with Martin. If you have any interest in Martin Willems, if you have any interest in disability law, attend that. Martin is very knowledgeable about all things disability law, so certainly you're going to want to attend that if you have interest in disability law. Thanks for joining us. I'll see you again here in 2 weeks at my usual time slot of 10:30 a.m. Pacific time. Otherwise, have a wonderful and safe weekend.